Welcome to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. In each episode, you'll meet industry leaders, innovators, and educators in litigation. We'll discuss the latest advancements, efficient practices, and strategic updates. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Now here's the host of What's Cooking in Litigation, Brian Wacker.
Hello, and welcome back to What's Cooking in Litigation. I am your host, Brian Wacker. We are back for our second episode. Each week, we are going to be breaking down trends in litigation and chatting with people who we think are some of the sharpest minds in the industry, including those within our own firm, the Cook Group. Getting to the heart of what's happening in litigation. We're not going to get too much jargon or fluff. We're just going to talk insight and substance. So with that out of the way, joining me today is another one of my partners, Hanson Horn. Hanson, welcome.
Brian, thanks for having me today. Excited to be here.
I could not be more excited to have you, Hanson. We spoke with Carrie Ann last week, and another one of my great partners from New York, based at our New York office. And so, Hanson, today we're going to be talking not only about an exciting presentation that you've got coming up. Next week I'll be there with you and for moral support, of course. But first, let's take a few minutes and get to know you a little bit more. Hanson, can you just give us a little bit of your background, your experience as a lawyer?
Sure. I am about a 15-year attorney. I am, as you mentioned, I'm a partner here at the Cook Group. I'm the managing partner of our South Florida office. Most 80%, 90% of my work is Florida-based, although I am heavily involved in the New York practice. If you cannot tell, this is not a South Florida or New York accent. The first half of my career, the first 6-7 years was spent in New Orleans and South Mississippi. Throughout my career, I've handled litigation defense, a little bit of everything. It's one of those things, if it's litigation, I feel like I can handle it. I've handled products liability, toxic tort, which is those two areas is kind of the focus of my practice today, but also commercial litigation, premises and property. And then in my early years, handled a good bit of medical malpractice and government and municipality defense. So a long way of saying a little bit of everything.
Jack of all trades, master of nothing, right?
Yeah, exactly.
I can join you on that one. All right, so obviously you're from the South, but you practice in New York. What has brought you though to have that substantial practice of yours and managing practice down in Florida?
Yeah, I laugh, Brian. I feel like it's manifest destiny that I become a Florida attorney. When I was down south, when I was in South Mississippi and New Orleans, we had some clients. Firm I used to work for a great regional Gulf Coast firm, asked me to take the Florida bar to handle their clients there. I did. I moved to New York City to become a big city lawyer. One thing led to another, and I was flying to South Florida every week and managing the office there, and I'm still doing that today.
All right. Well, you've passed both the Florida and the New York bars, so at least you're good at taking tests, right?
Hey, don't forget about the Louisiana, Mississippi.
Yeah, that's right. Just like those are like 4 different types of law. You can't.
Whenever I get bored, I just sign up for a bar exam.
Right. So, what is it? I'm well aware of this, having been your partner in the firm. But can you tell the viewers at least, what is it that's making Florida so ripe for this high stakes litigation recently?
Florida has been, and whether I know people in the legal community, I think, see this, has been subject to a lot of statutory changes, amendments of late that have really affected litigation. Recently, a lot have been to the defense bar's favor, but Florida's it's a very litigious state. You have the factor of that it's growing at a rapid pace. Businesses are relocating there, and anytime you have more people, anytime you have more business, that creates the opportunity for litigation. There were some rules that were very plaintiff friendly that encouraged litigation. The playing field's been leveled a little bit, although I would still argue it's still plaintiff friendly. And then even here as of late, there's new amendments to the Florida Rules of Civil Procedure effective January 1st of 25 that really expedite the trial process. So if you're a plaintiff and you want a trial date, you can get one. You can get one quickly. I know I've seen an uptick in trial settings. So, it makes it for these claimants who really want their day in court. They can get it in Florida, and there's some, high verdicts. I think a lot of it correlates with the times, with the amount of wealth we see in South Florida. I think there's definitely a correlation to verdicts and just the overall economy. Also, a factor is remittiture is I'm not going to say absent, but it's rarely available in South Florida, which just allows for some large verdicts.
Sure. Yeah. And it's one of those things I notice it here in Missouri and a little bit on the Illinois side, that folks try to potentially, assign a given state based on its political leanings to be somehow have some correlation with how the jury pools are or how verdicts are. But in reality, I mean, it's not always the case. It's kind of a crapshoot depending on the jurisdiction, the local jurisdiction you're in.
You're absolutely right. South Florida is typically known, and when I say South Florida, I mean Miami-Dade, Broward. You think of the larger verdicts there, but also practice in the Panhandle a lot, and we see some really large verdicts there up in Bay County and Escambia County as well. Yeah.
Well, so speaking of the South, you and I are going on a bit of a I don't even know what I would call it, but we're heading to a convention next week in beautiful Charleston, South Carolina. It's going to be about 70 degrees warmer than it is outside of my office right now. We're going to be there with a group called, which I'm new to, but I know you've had some experience with, the Federation of Defense and Corporate Counsel. That sounds really, really fancy, and based on the price tag, I know it is. So can you tell us a little bit about what your experience has been with that organization?
Sure. I've been a member of the organization for a few years now, and I feel and I find it's a very high, a lot of legal professionals, also professionals in the from the insurance industry, as well as from the insureds and self-insureds and businesses themselves. But a lot of just high quality individuals. I have to say that, and I don't mind saying this, I'm often humbled by the presence of a lot of the attorneys that I'm around there. A lot of attorneys that I hope in 5 years, 10 years, 20 years, whatever it may be, that I can be in the same ballpark of them as far as legal acumen. So it's a really great. I'm excited about next week in Charleston, Brian. I'm excited to have you down there with me for us to conquer it together. But I think there's going to be a lot of good discussions, a lot of good people to meet, and I am speaking on a panel. I hope I can be half as insightful as a lot of the other panels that I know are going to be just really high quality.
Yeah, well, so speaking of high quality discussions, I'm just gonna read what I understand to be the topic or the title of the panel that you're on, and I'm gonna give you all the chance in the world to tell me what the heck any of it is. All right, it says hot topics and trends in environmental and products liability, MDL and class action suits, a comparative look at recent developments. Yeah, what does that mean?
That's right. And Brian, as you said, I even had to glance over at my notes to make sure I remember what the name of it is, because it is a mouthful. It is. I am on the Products Liability and Toxic Tort and Environmental Law Committee. We've kind of, and I know that's three very similar areas of law and also three different areas of the law, but we all, it's close enough, I guess is the way to put it. And there's a group of us, I think myself and I think three others. And we're just going to talk about everything that's been going on in this past year and some of the things ahead. There's a lot out there these days. Everything from how artificial intelligence affects things to the PFAS litigation, as we all know, is a hot topic. To what I'm going to speak about, and that's kind of the Chevron Doctrine in the environmental realm, as I think it's impossible to look at this past year and look at the year ahead of us and not mention or not address such a big decision.
Yeah, I know you and I we like to fashion ourselves as like the older attorneys, but you still have some of your hair, and if I were to really try to grow it out, some of mine might come back too. But we're I think old enough in our careers to remember back when, at least, that there was some certainty that we could have out there, right? We knew that there were certain doctrines, certain parts of Supreme Court jurisprudence that you can always count on, right? That we're not going to be necessarily disturbed, or even though they're being challenged in a number of different ways, you kind of were able to say, you know what, I learned about that in law school. If you learn about it in law school, it's not going away, right?
One would think.
One would think, right? But it's what you say. Times are changing. There's a lot of uncertainty out there. The judiciary looks a little different than it used to. So, yeah, you said you're going to be talking about the Chevron Doctrine. I remember the Chevron Doctrine from my Barbary class because I never took administrative law in law school, so I had to learn it on the fly. But can you tell us a bit about what the Chevron Doctrine, I guess, was?
I think I can. And Brian, I got to just make a comment. I mean, I'll tell you one thing. I'm thankful in law school that there was not a major decision overturned while I was in law school, because that really would have messed up my study guide, my preparation. Talk about throwing a wrench in things. Wow. But anyway, so the Chevron Doctrine, and like you said, it's referring to administrative agencies, and it's a 1984 decision that the Supreme Court established. Basically, the Chevron Doctrine is a legal principle that directed courts to defer to a federal agency's interpretation of a statute, of an ambiguous or silent statute that it administers.
Yeah.
It's basically, in short, a two-step framework. The court must determine whether the Congress's intent of the statute was clear, and if it wasn't clear, or if it was silent or ambiguous, then the courts should defer to the agency's interpretation, as long as it was reasonable. And for the sake of context, we're talking agencies. We're talking about, the EPA, the DOL, the EEOC, things of that nature.
Right. So in broad strokes, the idea being that, when Congress enacts a law and it doesn't address or have some sort of statutory language or background to it in terms of addressing every single situation that may come up within an industry or within an administrative agency's purview, that if it was silent on it, the Chevron Doctrine said, all right, we're gonna grant a little grace and levity and leniency to the agency to make its own reasonable interpretation, right?
That's exactly right.
Yeah, and so now it's been attacked over the years, and now we're not so sure it even exists anymore. Is that fair to say?
That's right. Here, in summer of 2024, the end of June, and it's really two decisions. We'll call it, they're collectively called the Loper-Bright decision. It's Loper-Bright and Raimondo that the court in a 6-3 decision overturned the Chevron Doctrine.
Right. So in a lot of ways, it's kind of saying, all right, well, that agency power that we had given, sort of depending on your view of government and all these things, we're not getting into that today, but we're gonna reel back, or we're gonna grasp back some of that agency autonomy or power that they had to interpret things.
That's exactly right, Brian. Courts now have to use their independent judgment in making these decisions, regardless of whether a statute is ambiguous or not.
Yeah. So, all right. So then let's kind of dovetail that into kind of the heart of what we talk about and what we do. What does this mean? I don't know. Not that you can look into a crystal ball, but I mean, I think in one sense, some folks may see this and say, this is going to lead to a scaling back of frivolous litigation and all these sort of things. I kind of might see it the other way. I kind of might see this might create more litigation and more uncertainty. What do you think?
Brian, it's funny. Whenever I was first doing my outline for the presentation next week, I kept using the two terms interchangeably, and I think it's fair. I want to say the title was something Chevron Doctrine. Whenever there's deregulation, there's litigation, but also whenever there's regulation, there's litigation. I think both are equally or can be equally true. Right. It'll be interesting to see how it plays out. And look, there's still a lot of to be determined out there. But I think it sets up for a lot of businesses to make challenges to regulations, that agency administration that they see as overstepping. Right.
One of the things that this is before I kind of dug into this and put together some of my questions, but one of the things that jumped out to me is, in a lot of what we do, whether it's environmental or toxic tort litigation or product liability, we rely pretty heavily on experts, right? Experts who come up with, their own opinions as to duty of care, standard of care, things like that, and whether things have been breached or not. And, those experts rely a lot on regulations. They rely a lot on what the agencies are saying. I think this is going to change a lot of what they can and can't rely on, and what is even out there to rely on.
Brian, you're absolutely right. And if asked the question of what does the Chevron Doctrine being overturned mean as far as litigation, to be quite frankly honest with you, I don't know. But I can see the trickle down effects, kind of as you're implying here or alluding to. Whether it's asbestos litigation, you see the references to OSHA standards. Exactly. The talc litigation, you see references to the FDA. I don't see how, whether it's today, tomorrow, 10, 20 years from now, I feel like there will be some kind of reference or touchback to the administrative or agency interpretations and the deregulation here.
Yeah. And one thing that I see a lot of in my work with employment law, right, is that, we've got not only your state agencies, which, to be clear, my understanding of the Chevron Doctrine is it really doesn't touch on state power and state administrative powers. But with respect to, a claim that's brought for discrimination or for some sort of wage and hour thing, or any sort of claim that a company or an entity or corporation is facing from an employee, oftentimes a crafty plaintiff's attorney is going to avail himself of, EEOC standards or rules and regulations that the Department of Labor has put out. I think that ultimately this could have some trickle down effect on that to say, wait a second, those things they're no longer, if they get challenged or they no longer have the heft that they otherwise sought. So in one way, it could be good for the industries, right? Maybe I'm just saying exactly what you're saying, but across every industry, across anything that has any regulation on the federal level, we're kind of in the Wild West, it seems.
You're exactly right. We speak of and I know I'm speaking the environmental realm next week. You think of the EPA and you think of the big decisions out there like West Virginia versus the EPA and Louisiana. There's a case in Louisiana pending, or an injunction's been issued against the EPA. You think of those, but it's so much broader than that, from the Department of Labor to the EEOC, how it can affect the, employment realm, with the fiduciary duties and the ESG realm, sure. and investments. I mean, even in the workers' comp sense, the Medicare Set Aside Act, I think it has the potential to have a broad, to touch a lot of areas, and whether these areas are necessarily or the crux of lawsuits, you certainly see them at least brushed against in private actions all the time.
Yeah. And, the other uncertainty that is really out there that, we're not going to say out loud, but I guess we will now, is that, as you and I know, not every judge thinks the same way, right?
That's exactly right. There's probably going to be, you can probably take two different states or two different jurisdictions, and you're going to get some different decisions.
Yeah, and if we're handing some deference back to the courts to interpret, man, it's going to be we're going to see some judge-made law as opposed to some administrative or executive-made law.
That's and that's what, when it comes down to the people in favor of overturning Chevron, the people against it, in two broad sense or two broad camps. It's those who are worried that now you have judges, who, regardless of legal acumen, are making complex decisions in very technical areas of the law. Those who are happy to see Chevron overturned are those who see Chevron as a facilitator of an overreaching government.
Yeah.
Or administrative state.
And all the more reason why, our jobs as lawyers is even more important in those circumstances.
Absolutely. In your realm with handling clients and small businesses, especially, there's a lot of uncertainty about how to apply, or not apply these, administrative regulations.
That's exactly right. All right. Well, so we've kind of winded down on Chevron. I guess just the big question I've got for you about your presentation and everything like that, and next week down in Charleston is, where are we going to eat, man? I hear the food down. I haven't been down there since I was very young. So what's the move when we're down there?
Hey, I got a list of my sister-in-law and brother-in-law live there, so I got a list of recommendations for us. So as soon as I get finished Tuesday morning, you and I are eating something good.
Good. All right. Well, we'll talk offline about that. So, all right, Hanson, I want to thank you for joining us today. I know that's been a busy. It seems to me that February is the shortest, but often the busiest month of the year for us litigators. So appreciate you taking the time, and we will see you down at the FDCC winter meeting 2025 down in Charleston, South Carolina, and looking forward to that. And I'm sure you're going to wow everybody down there with your grace and humility and your dashing good looks.
Well, I expect you to throw me a few softballs when you're in the audience Tuesday morning.
I'll put them on the tee for you to knock out of the park.
Brian, I really appreciate it. I've enjoyed it this afternoon, and thank you.
All right, brother. All right. Well, that is it for another episode of What's Cooking in Litigation. Thank you all for tuning in. If you found today's discussion helpful or interesting or even amusing, please be sure to subscribe, hit the like button on the video or wherever you find your podcasts. And please leave a review. We'd love to have it helps us, and we'd love to hear back from you. So until next time, everyone take care, stay informed, and we will see you on the next episode.
You've been tuning in to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Thank you for sharing this show with others.